Hello, everybody. My name is Nick. Happy Friday. I'm the managing partner of Torres and Zheng at Law, a business law firm based here in New York City, and we're located at Hudson Yards. So this is the T&Z Friday Brief, where we give the latest updates on some trends and news going on in the business law field here in the United States and internationally as well. So one update that I wanted to share is about SPAC IPOs. So we specialize in doing SPAC IPO listings, and a SPAC, as you may or may not know, is a special purpose acquisition corporation, and it is formed for the purpose of combining with another company. So there's two ways to go public. The traditional way is for a private company to complete a registration statement and do a traditional initial public offering of its shares. That's option number one. Option number two is the backdoor route, where they actually merge into a publicly listed company, and that's the purpose of a SPAC IPO. So the SPAC IPOs have been very popular in recent years, especially during the COVID time, where many companies were forming SPACs, and then once they're listed, it takes about 3 to 4 months to get listed, and their shares are traded. Then they seek to go combine with a private company. So this has been a creative and very popular way for private companies to go public by merging with a SPAC. So what we've noticed is traditionally SPAC IPOs have been listed on NASDAQ. And NASDAQ is one of the most popular national security exchanges in the United States. And then there's another one called NYSE, New York Stock Exchange. And so traditionally SPACs have went to NASDAQ to do their initial public offering. But we found that recently they're getting stuck there. So we're talking with other underwriters and financial advisors and sponsors in the market, and we're also reading the news and looking at the filings, and we're just noticing, especially in our own experience here, that they're just not getting approved. The SPACs get to the final finish line with NASDAQ, and there's been no updates. And NASDAQ's still engaging with our clients and with the SPACs, but they're not doing the ultimate approval. So if you just look at the public filings, what we're noticing in these SPAC IPOs are going from NASDAQ and starting to switch to NYSE. And there's a trend here. So they tried to do NASDAQ and global, and then switch to NYSE. Now NYSE, there's two different exchanges on NYSE. So you got NYSE and NYSE American. Now NYSE has a higher listing requirement. So if a SPAC goes from NASDAQ and then it looks to switch to NYSE, they have to make sure that they fulfill the listing requirements there. And we're noticing this trend. So they're all going there. All the SPAC IPOs, it appears that the trend is they're leaving NASDAQ, they're going to NYSE. Now, if they can fulfill the listing requirements for NYSE, that's fantastic. There's not a big material difference. But if they cannot fulfill the continued listing requirements for NYSE, then perhaps they have to explore listing on the other stock exchange called NYSE American. And the issue with NYSE American is that they don't recognize rights. And so SPAC IPOs have units, they have rights, they have shares, and warrants. So if a SPAC IPO wants to list on NYSE American, then they might have to restructure their deal and either upsize it so they can meet the requirements for NYSE, or they have to get rid of the rights. So it's just something to keep an eye on, explore in the market. We'll let you know how it all turns out. We'll keep giving updates on the latest trends in the business law field and in securities especially. And we look forward to seeing you next Friday.